No. It's always good. I rise to speak on behalf of the Coalition on the Bail Amendment Extension of Limitation on Bail in Certain Circumstances Bill 2025. This bill seeks to extend the operation of Section 22C of the Bail Act for a further 3 years until the 4th of April 2028. When Section 22C was originally inserted into the Bail Act, it was to have a 12-month sunset clause. This was by design. In the second reading speech given by the Attorney-General on the 12th of March last year, he said of this new provision, quote, "The Bail Act change is in proposed new Section 22C is a time-limited, targeted amendment. It has been purposefully designed as a circuit breaker to address repeated alleged offending by young people aged between 14 and 18 who have been charged with serious break-and-enter or motor vehicle theft offences while on bail for another offence of that type. The original bill introduced a new test under Section 22C that the bail authority must not grant bail to offenders between the ages of 14 and 18 charged with those offences while on bail for another offence unless the bail authority has a high degree of confidence that the young person will not commit a serious indictable offence while on bail. The test of high degree of confidence is a test that still has to be developed in terms of what it means, with several Supreme Court justices observing unfavourably that it is a test that is not known to the law. For the judiciary to say that something is not known to the law is usually not a flattering observation. In his 2024 second reading speech, the Attorney-General made it clear that the new bail test for young repeat offenders, quote, has been approached cautiously. And he continued, that is why this change is time-limited and specifically targeted at young people who are already alleged to have committed at least one relevant offence whilst on bail. He continued, the provision will sunset after 12 months with an evaluation to take place at the end of that period. In his 2025 second reading speech on the current bill, which seeks to extend that sunset clause, the Attorney-General did not suggest what the results of that evaluation have been. There was no reference at all to crime data and the impact of Section 22C on the relevant offences, on different localities, or on youth crime offending generally. The closest we got to an evaluation was a concession that Section 22C does not appear to have worked as the government had hoped. And in his second reading speech on this bill, the Attorney-General said, quote, the extension is intended to keep the additional bail test in place and keep the community safe while efforts continue across government to reduce youth crime through therapeutic and community-based solutions that aim to minimise a young person's contact with the criminal justice system over the longer term. Last year, the opposition sought to amend the 2024 bill to require reporting by the Bureau of Crime Statistics and Research, the New South Wales Criminal Data Research Agency, BOXAR. We wanted BOXAR to report data about the operation of Section 22C and related matters, including the number of relevant offences committed, the number of offences committed by 10 to 14 and 14 to 18-year-olds and those under the age of 10, and whether the relevant person or other individuals referred to were on bail at the time of the relevant offences were alleged to have been committed. We wanted that data reported in a timely fashion at regular intervals because we are all concerned about what is happening in the community. We want to make sure that measures are properly targeted, but without data, without any information, it is very difficult to know. This data has not been made available, and if it was available to us now, we would be in a much stronger position to make decisions about the legislation before us. We have had confirmed recently the importance of this House making fully informed decisions about legislation with all of the information available to it. And to be trying to yet again make a decision without full information puts us in a difficult position. And so we will again seek provision of government data to this Parliament on how Section 22C is operating. Given the delay with the provision of statutory reviews, and the recent example of the government in relation to provision of information, it is not enough that this data is provided to the Minister. All members in this place should have access to it. And we hope that the government and the crossbench will support us as members of the Parliament and the broader community having access to this data, which provides transparency to the operation of this law, which is the government's only youth crime legislative initiative. We are all keen for this to work well, but we need to know what is happening to be able to make that assessment. Provision of the data was previously opposed by the government on the basis that it was said to be only a 12-month provision. However, it's clearly not going to be a 12-month provision. The government wants it to continue longer, and 12 months later, no data has been provided to this House. So we would urge the government to reconsider its position in relation to that. In the Attorney-General's second reading speech on the Bail and Crimes Amendment Bill 2024, he said that Section 22C would, quote, work in tandem with a suite of measures and supports that aim to provide therapeutic and community-based solutions to address offending behaviour and support regional communities so that they can continue to support and care for their young people. I think this is a very important part of what needs to be a total response to youth crime rather than merely a legislative response. And indeed, the provision of the data about how the legislative response is working would also inform the nature and the type and the spread of supportive measures which should be part of this youth justice approach. In the 2025 second reading speech, the Attorney-General indicated that, quote, additional funding is being allocated to further develop and expand these programs. This is very welcome. It is good that additional funding has been allocated because sadly it appears that a number of the originally planned initiatives have stalled. For example, I understand that months later, some 12 months later, there is still no bail accommodation for young offenders in Moree. I understand that we are close, a word that we are used to hearing, and that soon a tender may be issued for bail accommodation in Moree. This is simply not good enough. We can't be focusing on legislative initiatives but letting the other part of the suite of measures that is meant to accompany this legislative initiative lag. And one of the reasons that we want the data is so that we can actually effectively debate what is happening about this issue as a whole. And one of the reasons that we will be moving amendments in relation to the sunset clause is so that the whole response can be reviewed in a timely manner, because we all agree that the best youth crime response is to prevent it altogether. The problems of youth crime have continued notwithstanding Section 22C and the wraparound services that have been promised by this government, but perhaps don't wrap all the way around all of the youth that they need to. The problem of increasing youth crime since the state election is sadly increasing, is not limited to regional areas or to certain areas in the regions such as Moree, even though this has been the particular focus of the government initiative. It is occurring all over the state. It is harming communities, it is harming people, it is making especially elderly people scared to travel and to be in their homes, and it is also harming the young people who are caught up in crime. We need an appropriate response. And we need to constantly review and monitor. This Parliament needs to constantly review and monitor what is happening in respect to youth crime. It is not a sufficient response for the government to take scrutiny of its response under Section 22C away from this Parliament for 3 years, with a sunset clause pushed out to April 2028. So we will be moving amendments to make the sunset clause end on the 1st of October 2026. This gives a 2.5-year period after its introduction for evaluation. This should be sufficient for us to evaluate if this provision is working, how this provision is working, whether this provision is working, what changes should be made to this provision to help it work better, and consider a possible extension by this Parliament again if that is after true consideration, with full data, the appropriate response to the continuing issue of youth crime. And that is also an appropriate time to let the government's wraparound services operate and for us to assess the impact of the total response, of which 22C forms one part. With respect to how the courts are applying the high degree of confidence test for the granting of bail, it is fair to say that there has been a mixed response and there has been some unwillingness by the courts to apply this test and refuse bail. It appears that perhaps the interpretation of this test by the courts was not that which was intended by the government when this test was introduced. Decisions such as Crown and TW, Crown and BH, Crown and TB, Crown and JS show a judicial concern rising in some cases to opposition to the fact that a different and harsher test is in place for children between the ages of 14 and 18 than applies to adults, even on a show cause offence under the Bail Act. The result has been that Supreme Court justices are being satisfied on a review of bail that they have a high degree of confidence under Section 22C that an indictable offence will not be committed on bail with appropriate conditions. It is a usual condition of bail granted by Supreme Court decisions, if the matter falls under 22C, for there to be either home detention or at least a curfew between the hours of 8 p.m. and 6 a.m. If the courts are going to continue to give bail in circumstances covered by Section 22C in a significant number of cases, then the government should be doing everything that it can in the interest of community safety to ensure that bail conditions are complied with. To that end, the opposition will move amendments to require that in the event that bail is granted for a Section 22C offence, because the bail authority has a high degree of confidence that the young person will not commit a serious indictable offence on bail, first, in the interest of community safety, there should be always a curfew on the relevant young person between the hours of 8 p.m. and 6 a.m. And secondly, to ensure that that curfew is met, the young person should be subject to electronic monitoring. It is to be remembered that the government introduced this legislation not for all offences, but for the most serious offences. Therefore, if bail is to be granted to serious offenders, it is not unreasonable that public safety is protected by the use of ankle monitoring to ensure that the conditions of bail are being complied with. Electronic monitoring of youth offenders is used in a number of Australian jurisdictions. It is not novel, and neither is the idea of a curfew. Electronic monitoring has dramatically reduced reoffending in domestic violence parole cases, as measured by Boxar. It is reasonable to think that a similar result would be achieved with regard to the reoffending rates by young persons with a history of committing serious break and enter or motor theft offences. Electronic monitoring has more recently been introduced for bail granted in domestic violence offences, where the government followed the private members' bill brought forward by the opposition. The introduction of electronic monitoring is a further support to judges who grant bail to enforce the conditions that they impose, as the court would no doubt want. Courts do not make orders without them wanting and expecting that those orders will be complied with, and that these conditions of bail fall into that category. Any bail granted under Section 22C, under the amendments that we're proposing, will be revoked in one of three circumstances. First, failure to comply with bail conditions. Second, the young person is charged with another crime. Or third, any interference with the electronic monitoring device. In order to ensure that this revocation operates appropriately, bail can be granted again only if the breach of bail was for a trivial breach, such as exceeding the curfew by a few minutes, or if there are other exceptional circumstances. This is not a mechanical test. It needs to be looked at in the individual circumstances of the young offender. It is a privilege for repeat serious offenders to be granted bail, having regard to the seriousness of their offences. By having clear consequences for their reoffending, the opposition believes that the existing laws, as amended by our amendments, will be tailored in favour of community safety. We've had the opportunity now to see how this legislation is being interpreted by the courts, how it is operating in practice, and whether there has been a reduction in youth crime. The opposition amendments address what we now know 12 months down the track in order to better protect the community, and that surely is the aim of all of us in this place.